co-ownership nature of strata has some great advantages that make strata property very appealing. For example, the cost of land is spread among many, making housing more affordable. And similarly, it allows owners and occupiers to share facilities that they might not be able to afford or want sole responsibility for if living in a detached house. But co-ownership also has some drawbacks, and first among these is a shared financial responsibility for the strata expenses. Australia's preeminent strata lawyer, Gary Bugden, has written that if a strata is short of funds because some owners do not pay their levies, then pending payment, the strata must re-levy those who are willing or able to pay. The net effect of this, he says, is that the burden ultimately falls to owners who are able to pay the levy. Theoretically, the other owners can be pursued to bankruptcy. After noting that at law a strata entity can't be wound up until all of its liabilities have been discharged, Bugden concludes that a strata is therefore like an unlimited liability entity, and when a buyer becomes part of a strata, as well as getting an interest in real estate, they are effectively acquiring an interest in and membership of an unlimited liability company. This will come as news to most strata owners, who will be aghast at the potential for them to become liable for the unpaid levies of co-owners about whom they know nothing. But there's more. The unlimited personal liability of strata owners could potentially include damages for death, injury and property damage. For example, if damages are awarded by a court to parties injured as a result of building defects or unattended maintenance work, and the strata insurer does not pay because of non-disclosure by the strata or because of failure to fix the property, then each owner can be levied and re-levied personally until the damages to the injured parties are paid. Once, experienced strata professionals might have said that the likelihood of something like this happening is so remote as to be negligible. However, in the age of combustible cladding, structural defects, leaky buildings leading to mould disease and global pandemics, this is no longer the case. Strata insurance for all of these things is not guaranteed if strata owners do not step up and discharge their legal and financial responsibilities. So where does this leave strata managers? Well, firstly, as employees, licensees and directors, you are not personally liable for anything that you do in good faith and in accordance with your duties. That liability goes to the strata management company that will have insurance to cover this risk. What it does mean, however, is that strata owners are more dependent than ever on good strata management. This is an opportunity then for good strata managers to demonstrate their real worth and accordingly be paid better.